Hello, everybody, and good afternoon. I'm Preston Byrne, sitting in for John Deaton, who's doing God's work by running against Elizabeth Warren in the Senate race in Massachusetts. I'm a crypto lawyer, and today's going to be a little different from your usual fare because I'm joined by Gabe Shapiro, the CEO of Metalx. Howdy, Gabe. And we're going to be talking about Metalx, which is a really interesting startup operating in the DAO and decentralized organization space. Before we do that, I think we've been asked by the host to provide a regulatory update of two cases that came down, or two decisions which came down in the last week or so. The first one out of Washington, which is the Coinbase insider trading case, SEC versus Wahi, and the second is talking about some jurisdictional issues that were raised in the Binance class action lawsuit, which is Williams versus Binance. So, Gabe, you want to start us off on that, or shall I?
I think, yeah, better if you
do. If I do. All right. So two cases came down last week. I'm cognizant that a lot of you guys are Ripple users. So some of you may recall from over the summer that Ripple Labs had something of a split decision in the second district of or the Southern District of New York with their lawsuit against the U.S. Securities and Exchange Commission. The SEC alleged that distributions of tokens were securities, and Ripple said that they weren't. And the judge came down two different ways. The first one was that they said that the token distribution to investors and institutions was in fact a distribution of securities. But interestingly, Judge Torres also said that the distribution of tokens via certain secondary sales, about 5% of the total, was not a securities issuance, because one of the elements of the Howey analysis, which is that in order for something to be an investment contract under the Securities Act, it needs to be an investment of money in a common enterprise with an expectation of profits arising from the efforts of others, and that one of those elements, chiefly the investment of money, was missing from those secondary sales because people didn't think that they were investing into a common enterprise. They just thought they were buying the tokens from someone else. So there was a case out west where two brothers were accused of insider trading by the DOJ, and they were sued for insider trading by the SEC on the basis that secondary sales of transactions in cryptocurrencies, which were about to be listed on Coinbase, they traded in those in advance, having advanced knowledge that they were going to be listed on Coinbase, right? Because if everybody knows that a coin's going to be listed on Coinbase, what happens? The number goes up. So essentially, the judge, in a default judgment, said against the brothers, because they didn't contest it, said that essentially these secondary sales of transactions were in fact also securities transactions, and so the SEC had jurisdiction. Gabe, what do you think about that?
Yeah, I mean, it's not it's not shocking, I suppose, right? It's you have to keep in mind the procedural context, right? It's a default judgment. They don't have sort of like a really well-developed case on the defense side, to consider all these issues. And you have a very unsympathetic defendant in front of you, right, in terms of the facts, because look, they basically abused confidential information to get a trading advantage, and that if you just kind of ignore all these technical arguments about what is a security, what is not, this basic thing of using confidential information to get a trading advantage in an investment asset over others is really extremely similar, right, to the securities laws, insider trading context. So, it's not a shock that this would be the result.
So what do you think about do you think the SEC is gonna harp on this? Do you think they're gonna say this is some great victory? How do you think they're gonna use?
Yeah, obviously they will, like in the upcoming Coinbase case. I think there was this, and then there was also the recent Shapeshift settlement, which also sort of, you could argue, implies that secondary transactions in tokens can be securities transactions, or that the tokens themselves can somehow embody securities. And so they will use these as sort of cheap shots in the Coinbase litigation and the Kraken litigation to say, hey, yeah, I mean, look, these prior results sort of imply that secondary market transactions and tokens can be securities. And Judge, you would be invalidating these results, if you decided otherwise, right? But of course, those past things are not dispositive as a matter of law, right? One is a settlement, right? Which is where the defendant Shapeshift neither admitted nor denied wrongdoing, right? And the other is a default judgment, right? So I don't think it'll be sort of like, it's not going to determine how the cases work out, but the SEC, of course, will use it as one of many spaghetti strands that they throw at the wall.
I thought Paul Grewal, so he's the and I may have butchered it, the pronunciation of his last name there, so sorry, Paul, if I did that. But he's the general counsel of Coinbase, and he put up a really funny tweet a couple of days ago with a screenshot of an amicus brief that they filed in a different case, I believe, where basically they list the SEC contradicting itself on this question of secondary securities transactions. In the Coinbase litigation, for example, they said, well, the tokens don't embody the investment contract. Then a couple of weeks later in Binance, they said, well, actually, the tokens do embody the investment contract, and so they should be treated as securities. So, do you think long term, what do you think needs to happen here in terms of resolving this thorny issue where people can't make up their minds as to whether these things are or aren't securities?
Well, I mean, yeah, I do. The inconsistency is honestly quite shocking on the SEC's part. I mean, I feel like it would have been easy for them to lay out like a really consistent, coherent theory of like, look, judges, if you don't cover the secondary transactions by the securities laws, there's like some giant loophole, and they could have just picked a lane, right? They could have either said, okay, the tokens are not securities, but almost all the transactions in the tokens are securities transactions, right? Or they could have said that, the token itself, sort of virtually embodies an investment contract, but they've just been all over the map on it. In terms of what should happen, I mean, I really have no idea. I think there needs to be legislation at this point, or it's just going to be a giant mess. But I'm also very nervous that whatever legislation is won't be very good or coherent either. So yeah, I just don't really know.
Fair enough. The other case I think that came up in the last week or so is Williams versus Binance, and in that case, pretty interesting stuff. Binance had a lawsuit dismissed because it wasn't operating in the United States. But the plaintiffs in that case, it's class action, so it's a bunch of individuals representing a class of users who lost money trading securities on Binance, successly managed to get
trading tokens alleged to be
securities on Binance. Excuse me. Thank you for the correction. So it's trading tokens alleged to be securities on Binance successfully got a court to say, actually, hold on a second, you do have jurisdiction here because Binance was offering this platform in and through the United States. There were servers based in the United States. And that's an interesting one. Sometimes, so I've seen, as you know, I represent technology companies, and it'll be interesting because sometimes you'll get an email from law enforcement, and they'll say, "Hey, we got a guy in Colorado, right? And we know that he threatened someone else also in Colorado. Could you tell us where your servers are?" And you'll be like, well, the first time it happened, I was like, well, why? And they're like, well, we just need to know, are your servers in Colorado or not? Because what they need to do is they need to prove a cross-border nexus in order to apply the federal rules, right? And so obviously federal jurisdiction in a federal matter implicating the securities laws requires some federal nexus. Otherwise, it's going to be a purely Colorado matter. So I found that was interesting because basically it opens up this huge new field of potential liability for people who are interacting with crypto, because as long as a plaintiff or a law enforcement agency or somebody can say, listen, this transaction was processed by a node in the United States or is processed by a server in the United States, all of a sudden US regulation attaches quite without regard to how many people there are in the United States who might have been, counterparties to that transaction. What do you think about that?
Yeah, well, I mean, the initial dismissal was like very good for me and my clients. It was like one of the few sort of extensible like defense side wins in the industry, I feel like, right? Because the plaintiffs had clearly alleged that Binance sometimes did allow Americans in, right? Whether by mistake or because it's like very small transactions. And even still, the judge dismissed it for lack of jurisdiction, right? So it was quite powerful in that sense. And the reversal is unfortunate, but the aspect of it that I really focus on, I think one should focus on, is yes, there was U.S. servers, but the judge was careful to say just the mere fact that there were U.S. servers involved, isn't necessarily enough. But what he really harped on is the fact that Binance sort of isn't hasn't embraced some other jurisdiction than the United
Mhm.
States, right?
Mhm.
They don't say what their jurisdiction is. They certainly are not a regulated entity in any jurisdiction, and based on that, the underlying principles of what's called comity among nation states weren't as strongly implicated to drive U.S. law not applying as they
Yep.
might be otherwise, and that seemed to factor into his reasoning. So my takeaway is, if you do not want U.S. jurisdiction to apply, and you're not perfect in avoiding U.S. nexus, right, including by avoiding all U.S. servers, which actually is very, very hard, and all these things, then you are probably it's probably good for you to clearly say, we are in this jurisdiction, to have
Yep.
some people in that jurisdiction, and perhaps to get some sort of license in that jurisdiction that
And
is
say in
not
your
the U.S.
and say
Yeah.
in your terms and conditions or terms of service, we're electing to be governed by the laws of Malta. So is this agreement, you agree that you're going to sue us in Malta, class action waiver, that kind of stuff, which honestly I'm kind of surprised they didn't have a mandatory arb clause. Interesting. All right, well, there you have it. So enough about the law, though. The reason I asked you to come on today is because I think for the listeners of this podcast, you do some of the most interesting stuff in crypto when it comes to actually merging the law, right, and legal structures with decentralized structures. So how I came across Gabe is basically all crypto lawyers at the beginning of when they become aware of other crypto lawyers, they secretly hate them because everyone's good in their own particular little domain. And they have their little fiefdoms and their little theories, and they compete with each other and all the rest of it. But over the years, I've gotten to know Gabe, and he's totally brilliant. And he's doing a new startup called Metalx. So I think I'd like to talk about that, but briefly before we do, why don't you just tell everybody, who you are, how you got into crypto, what was your journey from TradFi to crypto, and then we
Yeah,
can talk.
sure. I've been, and likewise on the brilliance and all of that, and the funny stories. But yeah, I've been a crypto lawyer for about 7 years, and for 7 years before that, I was a very traditional sort of Wall Street style mergers and acquisitions lawyer. I most of that time I worked at a big firm called Weil Gotshal, and I was really doing a lot of buy side M&A for tech companies. I was based in the Silicon Valley office, so Facebook, Oracle, PayPal, eBay, Applied Materials, Intel, these
Mhm.
types of companies, right? Big public tech companies. And weirdly, I came to cryptocurrency through cryptography, unlike most people, because I was like the lead associate on the Facebook WhatsApp deal. At
Yep.
the time, the big deal with WhatsApp was end-to-end encryption, which like no other app had. Signal didn't exist yet, etc. And so I was like, well, I started wondering like, what's the big deal with this end-to-end encryption stuff?
Yep.
And that eventually led me to cryptocurrency and other things. And I realized when I read about Ethereum, a smart contract is basically the same thing as M&A escrows that we do all the time, just
Yep.
without the bank that serves as escrow agent. And so
Yep.
it like immediately clicked, and I got obsessed. Yeah.
Awesome. So you got obsessed. So you left big law. You went and I believe you ran your own private practice for a little while. And so then you got and you developed a pretty impressive reputation doing that. So what's led you to your current project? So you're running a company called Metalx, or a series of companies which are known as Metalx. Tell us a bit about what Metalx is, what space it's in, and that sort of stuff.
Right. Yeah. So I had my own private practice for on and off for years within different firms, different boutique firms, and then I was GC of Delphi Labs, and basically what I found is that like I keep running into a similar issue with clients over and over again, which is that I can come up with some like really, really clever advice for them about the optimal way to structure like the governance of their protocol,
Mm-hmm.
and have like a DAO, but also have some sort of like more nimble kind of like multi-sig groups on the
Mm-hmm.
side, and how to make these interrelate. But um, they're all building very specific products of their own, very specific protocols of their own, whether
Mm-hmm.
it's like a credit protocol or an AMM or whatever it might be. And
Yep.
they don't have time to drop all that and design a bunch of governance software to like implement my advice.
Yep.
So after a while of this, I kind of realized, like all these people would follow my advice if they had an easy way to do it, but the actual tech to like link up the DAO and like these individual entities
Mhm.
in these specific ways isn't there. So like, why don't I just like build this, right?
Would you
And
could
so
could you explain what a DAO is for everybody
yeah,
on the
sure,
pod?
sure. So a DAO, I mean, people, this is an issue, right? People use the word DAO in all kinds of ways. I think there's like a spectrum of meanings the word can have. On the very broadest end of the spectrum, it means any type of group of people doing anything where any type of group activity that uses a smart contract for either holding the funds and or for like voting on the use of the funds,
Mhm.
right? And then the opposite end of the spectrum is this like much narrower meaning that I prefer, right? Which is like really comes, I think, from Stan Larimer's original paper talking about Bitcoin as a decentralized autonomous corporation,
Yep.
right? And with this meaning, it really means that it's something where all of the rules of the organization
Right.
are embedded in autonomous software, and it's sort of a flywheel, right? Like Bitcoin is a flywheel, and you could see individual BTC the way he saw it as they're like shares of an organization, like an on-chain organization. And
Yep.
so you pay the service providers in those shares, right? It's resistant to extrinsic manipulation. Its
Yep.
rules are either immutable or like they can only be changed in like a deterministic fashion through the use of the software itself.
Yep.
Those are kind of like the three main rules, and that would be like the purer version, of what a DAO means.
So basically when we're talking about a DAO or a decentralized autonomous organization, the purest vision is something like saying, well, Bitcoin itself or Ethereum through its validators or Ripple's UNL as they decide who they are from time to time. That is a form of DAO in that it's a group of people who've come together to do decentralized money, and that's the business purpose which they've decided they're going to collaborate on without going so far as to say it's a partnership. And then you have other things like MakerDAO, or Lido DAO or various other stuff where they've embedded other types of functionality like voting or governance, or in MakerDAO's case, interest rates and custody of security-like instruments and stuff like that, which in your view is a little bit less purist, right? And so, what are
I
the
think those are still pretty pure,
Yep.
because like they are all on chain, and like you can see all the rules. You can't really change them arbitrarily,
Yep.
but where it gets really crazy is when you have stuff like Juicebox or like
Yep.
Constitution DAO, where like people just raise a bunch of funds and then
Yep.
they're just like doing off-chain stuff. A lot of times, those more casual ones,
Mm-hmm.
they don't even have they're sometimes they're literally just multi-sigs, and the
Yep.
DAO part of it is just like a snapshot vote,
Got it.
and then like you have to trust the people to go and like honor the results of that vote. So
Yep.
though that's where I kind of start to think, oh, the word DAO is silly. So
Yep.
I've come up with this alternative word for that, right, which is cybernetic organization, or Borg, right?
Yep.
Which is like it's an organization of some sort. Maybe it's a venture fund, maybe it's some type of business, maybe it's some type of club, and it does use smart contracts,
Mm-hmm.
but it's not this sort of like broader cyber anarchic nation state transcending thing, because it has enough social off-chain stuff that
Yep.
you should still expect it to need like a legal entity and need these like natural language rules and things like that, right?
Yeah, so I think the interesting thing about the Borg proposals, I'm cognizant we're throwing around a lot of terminology. So what I'm picking up from you is that DAOs basically range from things which are very decentralized to things which are wholly centralized, just a multi-sig, using some branding on it, which of course can have some legal implications. So one DAO which had this problem was a DAO called Uki DAO, which was a DAO, right, which basically sat on a bunch of money, performed a regulated function, and the U.S. Commodity Futures Trading Commission looked right through that DAO and said, actually, members, because you've built out all of this functionality, right? You've kind of overbuilt your smart contract to do something unlawful. And so what we're going to do is we're going to sue you in your personal and individual capacities. And I think what the Borg proposal is kind of saying, listen, that this is an avoidable problem, because what you can do is you can take a DAO, right, a decentralized autonomous organization, you can reduce it to the absolute bare necessities, right, of operations, which is that there are a bunch of tokens, maybe there's some minimal voting, and the purpose of the DAO, right, is for people to agree that those smart contracts will maybe manage other smart contracts with other entities, which can potentially provide regulated functions in a regulated way, and we don't have to bake all this stuff into a smart contract. So let's say I want to start a DAO that does something. What is my relationship with? What's the difference between doing that and just building all the code in one smart contract, or a series of connected smart contracts versus saying, okay, we've got this Borg and there are other entities? What are the key differences between those two things?
Yeah, I mean, I think you put it very well, and I think you can view sort of the DAO as like a plebiscite, right?
Yep.
You know, it's something that moves slowly. It's kind of like if it does approve something, it's like the ultimate badge of legitimacy, kind of like everyone agrees. But naturally, that's not like when you're doing a lot of things, not everything can be decided by referendum, right?
Yep.
And like you have certain things that should be decided by a smaller group of experts, or they need to be decided faster. So, you know, I think a great example, like that I personally participate in is Curve, right?
Yep.
Curve is an on-chain AMM. It's actually very like its smart contracts are quite immutable and really trust minimized. You can see all the code, but there are just kind of like a few situations where you probably need pretty fast human input, right? Like there are big things where the DAO decides. Like the DAO decides, I think it's every 2 weeks, how to set incentives for different liquidity pools within it.
Yep.
So that's all on chain. But then there also are things that can happen like hacks, right? Like something is wrong with the code or like
Mm-hmm.
with a particular pool and people are stealing money out of it. So
Mm-hmm.
for that, they call it an emergency DAO. I would call it like an emergency Borg. But it's a few group of people, of which I am one,
Mm-hmm.
that can do a very small number of things on the protocol in their
Yep.
discretion, right? They can shut down a pool that is relatively new, like 60
Mm-hmm.
days old. They can literally just like pause it completely, and they switch it into like withdrawal only mode. So you can't
Yep.
make any more deposits, you can't make more trades, but you can you can just get your money out. And they also can stop like governance attacks, right? So like if someone has found a way to just like get a huge amount of governance tokens thrown at the stakers in a particular pool
Mm-hmm.
for bad reasons or due to some sort of hack, it can stop that, right? And so this is an example, like an example of making that a Borg would be putting it into some type of company,
Mm-hmm.
right? Setting forth these contexts into rules like, oh, it's only supposed to be in emergencies, right?
Yep.
And then the fact that so you use like an on-chain multisig to do it. I think it's like a 3 of 6 or something.
Yep.
And then you also have the ability of the DAO on a slower basis, if it disagrees with one of our decisions, it can ultimately override our decisions as well, right?
Got it.
So it's a mix
So
of off-chain
basically, yeah.
things.
So basically, you're kind of what you've done here is you've mimicked a structure which exists in the real world, right? Which is in structured finance, where you have different entities that. So basically, the central entity exists to sit there and then hold the asset and then reflect, the will of its owners or debtors or something like that. And then you have various other entities like a liquidity provider or a note trustee or someone like that that have limited discretion to do certain well-defined tasks that they carry out, and it's on them to make sure that those tasks are carried out in a regulatory compliant fashion and not on the actual owners of the DAO who have contracted with them to provide those kinds of services. And basically what you're saying is you can do all of this on chain now, right, by creating entities that are digitally native with appropriate legal wrappers.
Exactly. And so like there are a lot of these multi-sigs, but they have kind of two problems. Like one is that they're mostly unincorporated.
Mm-hmm.
And so that can create liability, for the people running them if there's a
Yep.
problem. And number two, it's that they usually have like social rules that are narrower than what they actually can do on chain,
Mm-hmm.
right? Like we can say, oh, we only intend to pause the contract in an emergency, but actually we could pause it anytime we want. Right.
Yep.
So if you add the legal wrapper and you define what's an emergency, right now suddenly you're holding true to that, and then you can also, from a technological standpoint, a multi-sig is just a multi-sig. It can kind of do whatever.
Mm-hmm.
But if you create a more specialized protocol for it, which we're doing at Metalx, we call them implants.
Yep.
These are modules that you can put on top of a multi-sig that connect up the DAO to it. Then you can let the DAO, you could like have, for instance, like a time lock on the multi-sig's action that then the DAO can step in and veto on chain, right?
Yep.
Or you could require both the multisig and the DAO to approve a certain action, and it's beautiful. And you can even do things like, it's just like a core tenet of corporate governance that if you're like, say, a director of a corporation, you are allowed to resign basically whenever you want. You can step down. With an ordinary Gnosis multisig, you can't unilaterally resign. The other people have to approve that you are no longer there.
Yep.
Our module would let the person resign, and this is just going to work much better legally and socially.
Awesome. This is super exciting, and I for one am really looking forward to seeing how it winds up. So where can people find you on the internet and find Metalx on the internet?
Yeah, so best place for me is I am at LEX_NODE. That's at LexNode on both Twitter and Telegram. So you can easily reach me, especially on Telegram. I usually respond to DMs. Metalx has a website. It's www.metalx.tech. So you can definitely check that out as well. Right now, it's just a landing page with like a waiting list thing, but you can definitely join the waiting list if you're interested. And yeah, we're kind of like all over, but those are the main places.
Awesome. Super exciting project, Gabe. Thank you so much for coming with me on the podcast. And listeners, I'll be seeing you a couple more times before Election Day. So thanks so much again.